is the Investor Connect podcast program. This is Hall T. Martin. I'm the host of the show, in which we interview angel investors, venture capital, private equity, family offices, and many other investor groups for startups and growth companies. I hope you enjoyed this episode. Thank you for joining us. Well, hello, this is Hall Martin with Investor Connect. Today we're here again with Chris Ezold, partner at Wisler Pearlstine. Wisler Pearlstine, LLP is a Pennsylvania-based law firm specializing in business, employment, and corporate law. They help startups and investors navigate legal challenges. Christopher, thank you for joining us.
Thank you, Walt. It's a pleasure to be here.
Where are you calling from today?
So I'm calling in from the office in suburban Philadelphia.
So today we want to talk about the fiduciary duties of board members. Many people invest in startups and they wonder what a board actually does. And so looking forward to diving into that today. So maybe my first question is, what are the primary fiduciary duties that board members must fulfill, and how do they apply to companies at different stages of growth?
Sure. You have general duties under the law to do things, to not do things. But when you take a position of trust, such as a board member of a company, or you adopt a child, or you're a foster to a child, or you're a doctor or a therapist, you have a position of trust with the people under your care or who have put their money and effort into your care. Then you have what are called fiduciary duties. These are a much higher level of care that you have to put in. And common fiduciary duties, and it depends a little bit state by state, are basically the duty of care and the duty of loyalty. And there's some other subsidiary duties that come out of that. The duty of obedience, make sure that you and the company follows the law. The duty of confidentiality, don't give out information of your company that you shouldn't, et cetera, things like that.
So how can board members balance their duty of loyalty with when they get conflicting interests, especially in startups seeking venture capital investments? There seems to be multiple things going on there.
So your last question you asked, how does this vary or change throughout the company's life cycle from very beginning to end? And the duties don't change. They're exactly the same. They're always the same. But the reality is at the beginning of a company's life cycle, if there are board members, those board members are almost always investors. In fact, they're probably the founders and maybe one outside advisor, maybe the CEO that you just brought on, something like that. So everybody except maybe the outside advisor is self-interested. They have equity in the company, they've put money and time into the company, and they want to make sure that they get as much back out of it as possible. And so there's a conflict there between the self-interest of these board members, which is natural, and their obligations, their fiduciary duties to make sure they act for the best, in the best interest of the whole company. They act in good faith for all the shareholders, not just themselves. This becomes a more complicated issue as time goes by when other investors, second, third, fourth tranche investors come in. They have different loyalties than the original ones sometimes. Then you have more outside advisors that come in. Maybe they get, 1/2 of 1% or 0.001. Maybe they're paid, maybe they're not. But their interest is much, much, much less than all the actual investors. And sometimes you get completely disinterested third-party board members come in who have no dog in the fight at all. And as you grow and as you add extra board members, and these board members come from different places with different interests, then you can get some push-pull. Because if everybody's a founder, they're going to want to do things one way. If everybody is not a founder, that's different, but almost always it's in between. And so you got that push-pull where some people want to do what's best for everybody, and a couple that may just want to do what's best for themselves. And that creates these problems where you have shareholder derivative lawsuits, where somebody in control of the board, because they have the majority interest, says, all right, well, this is what we're going to do, even if it's not best for everybody. And then some minority shareholders say, well, the company can't sue because you won't let it, but I'm going to stand in the shoes of the company, and I'm going to sue you, the majority owners, the board members who let this happen, the board members who are out of control but never told us, the shareholders, what was going on. We're going to sue you for breaches of your fiduciary duties.
So what are the most common legal risks faced by boards that fail to properly fulfill their fiduciary duties? What happens to them?
So there's two primary risks. One is you get a shareholder lawsuit, and that can get very expensive. If you're a board member who's engaged in some bad behavior, you could potentially face criminal liability if you've embezzled, if you have acted against the interest of the company knowingly to harm it in favor of a company you own outright somewhere else, etc. You could find yourself on the other side of a prosecutor. If the company is large enough, there's enough money, it gets the attention of the SEC and regulators, you could have regulatory issues. You could be debarred, no longer allowed to be involved in a company where there is the sale of equity to anybody else, because the SEC has essentially said you're so untrustworthy, we can't have you involved anymore. And then there's what I would call second level problems. People come in and they want to invest money and they want to see what's happening, but then they see the problems that are created by board members who have not followed their fiduciary duties and they don't want to invest. Someone wants to buy the company. They see the mess that's there. They back off. You lose the trust of your employees. You lose the trust of the board members. You lose the trust of the shareholders, of the industry, because this stuff always gets out. Bad behavior by board members tends to be something that people really like gossiping about. And it's very hard to keep that quiet. So those are the major dangers that board members face if they don't, you know, do what is best for the company and make sure that they adhere to their fiduciary duties.
Well, in what ways can inadequate documentation of decisions compromise the legal protection of board members?
So documentation's a really big deal. You can't prove that you did the right thing, that you made the right decision, that you tried to do the right thing, but you were outvoted, et cetera, without the right documentation. And there's a couple kinds of documentation here. One of the biggest bulwarks the board has against making a mistake and breaching their fiduciary duties, and you can do it by accident. A breach of a fiduciary duty doesn't happen when someone has bad intent and they want to steal money or intellectual property or something. You could just screw up really, really badly. You could fail to engage in the right oversight over the financial aspects of the company, over the management of the company, over the operations of the company. You could make a really bad decision about bringing in an investor or rejecting a contract, et cetera, because you haven't done your due diligence, you're uninformed. So you could have negligent as well as willful behaviors. Having policies and procedures that say this is how we're going to operate, and those are documents, and then documenting how you operate. We had this meeting, these are the people that were here, these are the subjects that were discussed, this is the vote, et cetera, can then show you have followed your policies, you've acted in good faith, you've done the best job you can. If the documents don't reflect that, if there's minutes and you have said in the meeting, this is a real problem, we need to have a third party audit because we're missing money that we should know where it is and we don't, and the rest of the board says, nah, don't worry about it, it's not a big deal, and you see in the minutes of the meeting that your objection, your concern is not there, then you need to make sure it either gets in there or you filed something, at least with the board, at least an email saying, hey, these minutes don't raise the issue I raised. They need to be there. The shareholders need to know. So at least you can show you've got a document that you did the right thing. You acted in good faith. You adhered to your duties, even though the others did not. That's one of the biggest problems with lack of documentation, especially at early stage companies, is people just start doing. Decisions get made, they aren't made with any kind of process, they aren't made with any kind of documentation, and sometimes the people, the founders, will just make decisions and the rest of the board doesn't know because no one's really been documenting. It just sort of happens that way. And all of a sudden, you have board members who don't know what's going on. A bunch of decisions have been made, and the processes haven't been followed because they don't exist. So having those processes in place is a really big deal, and following them is an even bigger deal, and documenting them is critical.
So, how can boards protect themselves against lawsuits related to allegations of fiduciary duty violations?
The number one protection is directors and officers liability insurance. You want to get D&O, you want to have it in place. Frequently, the articles of incorporation of the company say we must have D&O insurance. The articles will also frequently say, as long as everyone's acting in good faith, we will indemnify, we the company will indemnify these directors if they screw up. And sometimes it'll say, if it's negligence. Sometimes it'll say gross negligence. We'll cover you for gross negligence. They'll never say we'll cover you for intentional behavior. And the basic defense there is, I did the best I could. Mistakes were made. The company has to cover me if I get sued by a shareholder or somebody else because of what I have done. So you have insurance and you have the company indemnifying you. But then the next thing you want to do is have these policies and procedures in place. And I'm going to keep coming back to that. Process is your safety net as a board member. Documentation is your safety net. Transparency and disclosure are your safety nets. No one can get angry about you for not telling somebody something like you have an interest that you haven't disclosed, not giving information to the shareholders you were supposed to, if you ensure that transparency is how you operate and that information is given out, more information than maybe you have an obligation to provide, and that you're always very clear with everybody when you have any, even whiff of a potential conflict of loyalty or duties. And you do these things, you get the insurance, you make sure that there's indemnity in the operating agreement, the shareholders agreement, the articles of incorporation. And then you make sure day one, you get the right policies and governing procedures in place and you follow them and document them. And generally, you're going to be fine.
So, what are the warning signs that may indicate potential fiduciary duty breaches within an organization? What do you look for there?
Right. So I consider warning signs something that are not catastrophic. If you get notice that your company you've invested in just went bankrupt and you had no idea, that's not a warning sign. That's an implosion. Warning signs are you ask for information, but you're not getting it. The financials don't make sense. Money goes missing. Individuals are involved with a company out of nowhere that you have no idea who they are or why they're there, and they don't appear to have any obligation to the company, et cetera. Things move, offices, people, et cetera, move. Rats leave the ship. If there is an exodus of good people, you know there's a problem. So if board members start resigning, you don't know why, you better find out ASAP. And that means getting a hold of the people that left. And if they say to you, well, I got some sort of settlement agreement, I can't talk. They have a fiduciary duty to the company and to you as a shareholder. You've got to get that information from them. The board can't stop them from talking to shareholders to divulge bad behavior. So these are all major warning signs. And if you see them, don't let them go. Talk to the other shareholders. Sometimes these warning signs exist because some shareholders are engaging in bad behavior and they've got control of some of the board members, et cetera. Other times it has nothing to do with the shareholders. The more you talk with the shareholders, the more you'll know from their point of view what's going on. But you cannot let financial problems or lack of information continue. And you cannot let rats leaving the sinking ship continue. If that starts happening, don't wait. Get involved and find out what's going on.
Well, in the case of an investigation, how should boards respond to investigations related to potential breaches of their fiduciary duties? What should they do?
So, for board members, my big rules are transparency, good policies, follow your policies. These things, you're going to be fine. So you do the same thing with investigations. You don't stonewall them. You give them what they ask for. Now, if you've done something wrong and there's an investigation, as a board member, you get your own attorney and have them advise you. But now you've got a conflict of interest. How can you do the right thing by the company if you've hurt the company and you're trying to avoid liability? At that point, I think that board member has to step down. I think that conflict of interest is unwaivable and fundamental. But if you're a board and an investigation is happening, which is almost always because either the board has voted for it or the shareholders require it, you have to cooperate. You have to be transparent. You have to show them the documentation, hopefully, that you have been keeping from day one to show what's going on, and then answer the questions that have been asked. Anytime the board pushes back on a legitimately authorized investigation, that's not a red flag. That's 4 or 5 red flags.
So how can boards implement effective policies to ensure ongoing compliance with their fiduciary duties? What do they do there?
So, what I tell my clients is don't wear hats that you don't wear. If you are not a financial professional, don't do your own books. Don't run the finances of a large organization. If you are not very familiar with operations, don't start making operational decisions contrary to the experts in your company. Things like that. Here, unless you have experience with corporate governance, with these policies and procedures, don't Google it. Don't pull something down off the internet and just follow that, because your policies really have to be tailored to your company and your business operations, your cap table and structure, and what you want to do. Where are you going with this company? Are you going public? Is this just going to be making money for the owner for some time? Do you have an end date for a liquidity event? You really need to know this to put together a good set of policies. So that means getting someone who knows what they're doing. Frequently, that's someone like me, an attorney. Every once in a while, you can have a corporate governance specialist, someone who's not an attorney, but they've done an enormous amount of this work. And if they're on the board, they can then help you with that. But most boards are not normally equipped to do this because the law and the case law make clear what you need to have. And if you don't know that, if you're, not practicing in this area, I would say don't try it. Get the right person to do that. And this is another one of my mantras for my board member clients, which is get your professionals, get an accountant, get a lawyer. If you need a professional of another stripe, get them, get their advice. Because if you as a board member rely on the opinions of the professionals who advise you, it's very hard to hold you liable if those opinions are wrong. You're not an accountant. You're not a lawyer. You're just doing what the board was advised to do by the professionals. And if they screwed up, it's bad. It's not good, but it's not your fault as a board member if you followed reasonable advice of a professional.
Well, in what ways does diversity on a board influence decision making and the fulfillment of fiduciary responsibilities?
Right. So, one of the biggest problems with boards is culture, especially echo chamber culture. If everybody's the same, they're from the same place, they have the same backgrounds, and they all got together to do this one thing, they're all going to have very similar approaches and opinions most of the time. And they're going to reinforce each other. And sometimes they don't see the obvious. Sometimes they reinforce each other and make bad decisions that wouldn't be made. A diverse board is one that has people from different backgrounds, from different parts of the country. They have different socioeconomic backgrounds, different professions. Obviously, somebody related, with real input into what you do. You don't want to just pick random people. But the more you have a different set of viewpoints, the more likely you're going to see the pitfalls in front of you. Someone will see something that the others do not. And that makes it much easier to do your job in good faith and meet your fiduciary duties, because one of them, under the duty of care, is competency. You need to know what you're doing. You need to make sure that you're informed about the business of the company, what's happening in the industry, so that you can make decisions. Board members don't just get to do whatever they do in their normal day-to-day lives and start making decisions about the business that they're a board member on. They need to be educated and understand it. And it's hard to do that if everybody is coming from the same place. Everyone is an engineer with a particular background from a particular school, et cetera. They're not going to see what someone who's got a background in finance or someone who's got a background in operations or human resources. They're not going to see these things. And very significant errors can occur. And the duty that gets broken there most of the time is the duty of care. You didn't keep yourself informed. You didn't do what you needed to do to make sure that you had the right viewpoints, you had the right information and advice.
And so, what specific challenges do boards in highly regulated industries like healthcare and biotech face in meeting their fiduciary duties?
So, one of the big problems with highly regulated industries is your duty of care, the duty to be educated and understand, is much harder to meet because it's a much, much more complicated business. If you're running a logistics business, there are a significant amount of regulations relating to trucking, to import, export, et cetera. If you're running a flower business, not so much. If you're running durable medical equipment businesses, then you've got FDA issues, you've got liability issues, you've got a whole host of state and federal regulations to be aware of. It is dizzying. And so you need to make sure that you're educated. This heightens your need for professionals. So you don't just need a lawyer. If you're running a pharma business, you need a healthcare attorney. You don't just need an accountant if you have complex financials. Because of this industry, you may need auditors. You may need a specialist who gets drugs through the FDA, a consultant who knows how to go through the process, what to do when, what the FDA wants to hear, because this is not what you do. You don't know it. Now you need that right expert to tell you. Your duty also, your fiduciary duties require you to oversee the company. Your duty of oversight is harder to satisfy if you have no idea what management should be doing, because it's a very complicated industry, what operations should be doing. You're just going to do whatever management tells you they think needs to be done, even if an experienced person in the industry would say, that's crazy. Management's out of its mind. You're going to get smacked with a huge fine. Do not do this. You need to know that. And that means if you don't have that expertise, you need to make sure the board has access to that expertise and get educated about it. So ethics, risk management, they can become much more difficult. And the gray areas are much harder to find. Gray areas are great areas for innovation, where either from a legal or a business or other point of view, you're not exactly clear what is and is not possible. Finding opportunity frequently happens in the gray areas. That's where some risk gets taken. You can't evaluate that properly if you don't know the industry because of how complex it is. But you also won't even see them. And so you could be missing very significant opportunities for the company that you're a board member. Making sure that you have the right people to tell you what's going on and keep yourself educated becomes much more difficult in a highly regulated industry.
Well, a few years back, I made an investment into a startup, and 2 years in, the CEO filled out the board with basically junior employees and used that as cover to start making decisions to benefit the
Right.
CEO and at the expense of the investors. They would vote themselves higher salaries. They would decide not to pay vendors. They would put the company into near bankruptcy for those decisions just so they could take on more. And we went to the board. We went to the board and said, "You have a fiduciary duty. You're supposed to be representing the investors, and these votes are not representing the investor. You're representing the CEO. You have legal liability with that." But they were so junior, I don't think they really knew what the word
Yeah.
fiduciary meant. What should we have done in that situation?
So, first of all, the CEO shouldn't be appointing board members. And if the CEO was doing that because they happened to be the majority owner and they were the founder, the documents that you signed to buy your interest, and then the resulting corporate documents, the shareholders agreement, et cetera, if they didn't have the right protections for you to have board members on, then that was the first error. And so your professional should have advised you on that. Next, you need to take a look at the law for the procedures for removing board members. Just because the documents say one thing doesn't mean that's the end of the story. The law, depending on what state you're in, will give you certain rights to do things anyway. And if the board is abusing its power, ignoring its duties, then you get a good attorney and you send a letter saying, you guys have a week to do A, B, C, D, E. If you don't, we're filing suit. And here is why. You violated this, you violated that, these duties, here's the law, and you'll be responsible for XYZ amount of dollars. You have X amount of time. You want to press them hard. You don't give them a lot of time. You want to put their feet on the fire, because the only time you're going to get movement is when they feel pain. And what you hope for is that these junior people who don't know what they're doing, one of them has somebody, a parent, a relative, a friend, who says, get your own attorney. And that attorney will sit down and look at everything and say, well, you got a problem. And that junior person will then tell their friends, the other junior people, oh my God, my lawyer said I've got a problem. I could be liable for hundreds of thousands of dollars, et cetera, et cetera. All of a sudden, everybody gets upset because now they realize they've been taken for a ride by the older founder CEO who they all thought was a mentor, but was using them.
Well, that's good advice. We're going to remember that for the next round for sure. And
I sure hope you don't have to.
I hope so as well. We've learned our lesson for sure on that one. Well, in the last few minutes that we have here today, what else should we cover that we haven't?
One of the issues is, what if you're a board member? Because it's one thing if you're a investor and you see things happening. What if you're a board member and things don't feel right? Things are strange. You're not getting information. Decisions are being made without your even knowing, et cetera. Get out. You resign in writing. You say, I'm resigning because I'm not getting information. I'm not getting input. Decisions are being made without me. You cover yourself to make sure it's clear that you had nothing to do with the things that have been happening, and you resign. Because the sooner you resign, the sooner your obligations, your fiduciary duties are cut off, and the less liable you are going to be. So you need to be very, very careful about other people's bad behavior too. You can't just sit there and let this behavior happen. You may actually have an obligation to go talk to the shareholders and let them know. And again, that means finding your own attorney to give you advice on how to do that. So just sitting there and letting other people do bad things and saying, oh, I had nothing to do with it, that's not going to be good enough. And so board members need to be aware of that. The other thing is, always put everything in writing. I'm dealing with a matter, very, very complex matter with an enormous amount of money involved, where a board member who had come in with a lot of money, invested a lot of money, said to the company, okay, we're going through this next step. I've got X millions of dollars. It's in the bank. I found these other investors to come in. They're going to invest through my entity. We're going to put the money in. Go ahead and start these projects that were expensive. And the board said, fine. The money never came in. Now, the reason the money never came in may be because that particular board member was hoping the company would get very desperate and they'd be able to buy the rest of it on pennies on the dollar, because there was a staggering amount of value in that company. Make sure, if you're a board member, no matter how much you trust anybody, other board members, et cetera, you get it in writing. If they say they're going to put the money in, get a contract that says we're putting the money in. Don't go making decisions that put the company into a bad position and take the risk that somebody's not going to put the money in they said they're going to put in, or whatever else it was. No matter how much you trust people, your obligation is not to the friend, the mentor, the colleague that you trust. Your obligation is to the shareholders. And so you always have to keep that in mind and say, if I didn't know the people I'm dealing with, would I be getting a contract? Would I be getting something in writing, et cetera? And if the answer is yes, you do it. And if your friend or colleague gets upset and says, you don't trust me, et cetera, you can simply say, I have no choice. This is again where it's good to have general counsel. Nothing I can do. My attorney's a jerk. He's making me do this. I mean, that's what we're here for. Attorneys are here to take that flack. We're here to get run over by that bus. It's the first course we get in law school, and it's the last course we get before we go out. So most of your attorneys will be willing to say, yeah, use me as the bad guy. And that way you can have some cover from that flack while at the same time doing what you need to do.
Well, that's great advice. So how best for listeners to get back in touch with you?
My website is www.wisperl.com, Wisperl. We have the General Counsel Initiative for small and emerging growth companies and mid-sized organizations that want to outsource the general counsel function. You can see some of the information there on that. And you can always reach me at Cezold, that's Cezold at wisperl.com.
Great. We'll include those in the show notes. I want to thank you for joining us today and hope to have you back for a follow-up soon.
Thank you all. It's an absolute pleasure to be here.
Investor Connect helps investors interested in startup funding. In this podcast series, experienced investors share their experience and advice. You can learn more at investorconnect.org. Halty Martin is the director of Investor Connect, which is a 501c3 nonprofit dedicated to the education of investors for early-stage funding. All opinions expressed by Hall and podcast guests are solely their own opinions and do not reflect the opinion of Investor Connect. This podcast is for informational purposes only and should not be relied upon as a basis for investment decisions.